Hello, my name is Paul O'Rourke. We're back with another session of Perspectives with Paul. And this session we're going to be talking about stop and frisk. And the question is it legal? And the answer is yes, if certain criteria are met. To look at whether the criteria are met, we have to first look at the Fourth Amendment. And the Fourth Amendment is in the Bill of Rights, and it says the rights of the people to be secure in their person, houses, papers, and effects, or their things, from unreasonable searches and seizures shall not be violated. In other words, if a search is considered unreasonable, then it's not a valid search. And so one of the things that the courts have looked at is a warrantless search. So if there's a warrant, the search is generally going to be found to be valid, at least for an arrest or a search of a person. So the next step is if a police officer is stopping somebody, usually it falls into one of three categories. Either it's what they would call a consensual stop. In other words, there's no burden, the officer's just making contact, it's a voluntary contact, and so there's no burden with that, and the person is free to go at any time. So if you had a consensual contact, and the person says, am I free to go? The officer says yes, then there's no burden there, there's nothing met, and the person's free to go on their way, they don't have to stop and talk to the officer. The second one is a detention, okay, and it's usually an investigative detention, and there is a burden for that, and that's reasonable suspicion. Reasonable suspicion is facts and circumstances that would lead a reasonable and prudent person to believe that a crime is about to, or has been committed, and the person's involved. At which point the officer can detain somebody, in other words, temporarily stop them, to further an investigation to find out whether that person's involved or whether the crime's actually been committed. So, and that is the lower level of the burden that an officer would need to show. And the courts have basically said you have reasonable suspicion if an officer can articulate the reason for the stop. So it doesn't have to rise to the level of probable cause, but that criminal activity is afoot, basically, is what it comes down to. And then the third one would be an arrest, would be being taken into custody. And the standard that's required for an arrest to be made is probable cause. And that is facts and circumstances that will lead a reasonable and prudent officer to believe that a crime has been committed and that this person is involved. So in other words, they have basically firsthand knowledge or knowledge that would lead them to believe a crime's been committed and this person has been involved. And so one of those three, well, reasonable suspicion being the lower of the burdens, is required for the detention. So the next part of that is, so that's the stop part. The next part is the frisk. And what is a frisk? A frisk is is considered a search. Okay, it's a search with probably the minimal invasiveness in the search. And the requirement for that is reasonable suspicion for the stop, and then a reasonable suspicion, something that an officer can articulate that says this person is armed and dangerous. So a criminal activity is afoot, crime is about to, has been, or is about to be committed, this person is involved, and that they can articulate that they believe them to be armed and dangerous. At that point, the officer has met, according to Terry versus Ohio, which is a Supreme Court case that came out in 1968, the officer has the right to do a pat-down search or a frisk. And the pat-down search is a pat-down of the outer clothing for weapons, okay? And it doesn't really cover contraband. And so there may be some questions of Miranda when you talk about this. And the reason I'm talking about that is if somebody it's commonly seen with holding drugs. If somebody's being pat down because they think they're armed, and then an officer feels a bulge, which may or may not be a weapon, most likely is something wadded up in somebody's pocket, the officer may ask, what's in your pocket? Now, if you turn around and say, drugs, well, you've just given them probable cause of search. But you haven't been Mirandized, and you're in what? Police custody, and it's asking a guilt-seeking question. So there may be some issues there. The point I'm going to try and make, and I'm not trying to redo Miranda, we've already done a video on that, is just to let you know there may be some issues. So what does an officer do, and what do you need to know about? Well, I will tell you, when I was a police officer, one of the ways that I got around the criteria for a frisk, for a pat-down search, would be I would get consent. And once you consent to a search, you have waived your objections that you may have had in court. So if you go ahead and consent to the search, you're not going to be able to say that the search was unlawful because you've already agreed to it. And so the way I would get around it is I would generally ask two questions. And they were pretty much the same thing, and they're pretty much the same thing even today, I would suspect, which is the first question when I got you out of the car, which was most likely, or when I had contact with you, if I was detaining you for something, I would ask, do you have anything on you that I need to know about? Anything that might hurt me, anything that might poke me, stick me, cut me, shoot me? And so the average person is going to say no. And if you say no, then that's fine, because my next question is well, then you don't mind if, and remember, I said you don't mind. I'm almost telling you, even though it's in the form of a question, you don't mind if I pat you down for your safety and mine real quick. And the average person will not feel comfortable saying no to that. And so, even though I phrased it as a question, I did it because I got more success out of phrasing it that way. And they say no, I don't mind, and then all of a sudden I pat them down, and if I find something at that point. If a person were to say yes, I do have something on me that might hurt you, then the officer can take that as an officer safety issue. And back when I was still a police officer, you didn't have, we got concealed carry while I was still an officer. So before that, it was concealed weapon, or you had a card on you. So if you were holding something, I would take it and seize it, even if that seizure was temporarily, just so that you couldn't hurt me with the item. Which is what the officer, what Terry versus Ohio talked about, was the officer seizing a weapon or saving a weapon to protect the people around the area and the officer himself or herself. Here's the trick. I know it won't feel comfortable, but you can be very polite and say, I don't consent to any pat-down search. I don't consent to any searches. I want my attorney present for any questioning. And that would be the way to handle that, in my opinion, to protect yourself. Now, that may not stop an officer or officers from doing a pat-down search or actually searching your person. It is ill-advised for you to use physical force to stop them from doing the search. The time to have that argument or that fight, and I mean that in a civil, that fight should be had in court, not physically on the side of the road. You will lose at that point. I just want to be real clear. There's a difference between the frisk and the search. A frisk is considered a search. It's a pat down of the other clothing. If you're arrested, the officer has every right and will do what's called a search incident to arrest, where they will take everything from you. And that's not just the outer clothing, that's inner clothing. You might have people that wear 2 or 3 layers in cold weather, those things. They will go through everything, and they will seize everything from you because you're arrested at that point. They will take it, they should inventory it, put it in. If there is contraband, then you can be charged with that. So again, do not consent to any searches, and ask for your attorney. If you're being stopped by a police officer, the first thing you should ask is, am I free to go? If the answer is no, then you should say, I want my attorney present for any and all questions, and I'm not consenting to any searches. Not of my car, not of my person, none of my things. So I hope this was helpful. I hope you like what you see. If you do, please subscribe to the channel. Please like us on Facebook, and let us know if there's anything in particular you want to see.